Hi, Justin. Thank you very much for coming on this morning to talk to me about all things contentious probate, contentious trusts. And I thought we're a really nice place to start with the fact that actually you and I both joined Rothley Law um, within a short space of each other. So over to you. Do you want to introduce yourself and
Sure.
tell me about your journey?
Thank you. Thank you. So my name's Justin Sadler. I joined Rothley Law in November 2024. And I think Heledd, you joined in December or end of November. So yeah, very recent. And I came from a background of general litigation. So I was a partner for about 10, 15 years at a company called Barrett and Co, which is based in Reading, and I did all kinds of different types of litigation, and I did enjoy it, but it's not easy running a practice. And after the pandemic, we sold the firm to a much larger firm called PM Law, and after basically making sure that everything was okay, stayed there for a year afterwards. I really wanted to get involved and specialize in contentious probate, which is a really fast growing area of law. And basically, I wanted to specialize because having sort of been a general litigator pretty much all my career, I came up against specialists and have obviously talked to people and really wanted to specialize because you can really get to grips with a particular area of law rather than just be a sort of jack of all trades. Um, and I suspect, I don't know if it was something similar when you joined.
Yeah, interesting. Actually, it sounds
Uh,
quite a fairly similar sort of journey that yeah, I'd sort of seen roughly sort of set up. Well, it's about 18 months ago. It's coming up for his second year anniversary, I think, isn't it? And I thought, oh,
mm,
that's interesting. Just a private client firm, and I'm
yeah.
always slightly of the opinion private client lawyers are with a Cinderella
Yes.
of the legal profession, but we never get the highs and we never get the lows.
Yes.
And actually, for me, the three strands of private wealth, court
Mm,
protection, and the disputed estate, catnip.
yeah. Definitely.
To be able to come in and just do that. So
Yeah.
contentious probate, though. I mean
Mm.
that's quite a hot topic at the moment. I think there's a lot of it out there.
Yeah, well, I mean, it has increased a lot in recent years. So the expression they use is blended families, but I mean that means sort of second marriages, people having relationships with other people outside the family, classically children from previous relationships and things like that. And you know the structure of marriage and families is getting more complex, and people are living longer, so they have more opportunity to remarry late in life and that sort of thing. But also property prices and wealth. The baby boomers are generally considered to be the wealthiest generation that's ever been, and they tend to be the people who are currently writing wills at the moment. And then there's sort of a bit of a cost of living crisis, so people are actually depending on inheritances in a way that they didn't before. So you know, young people can't buy houses; they're kind of depending on getting some inheritance from either their parents or their grandparents. So there's a real push in terms of the number of cases going to court and very much going to solicitors, because apparently I was looking at some statistics and something like 80% or 90% of cases are resolved after going to see a solicitor rather than actually going to court. So the solicitor's involvement clearly has a significant impact on resolving these disputes. And certainly, when I talked to the people at Rothley Law, and I was actually against them in a case, and that's how the connection initially came about. But there's that sort of almost bias towards trying to settle the case, which I agree with, because it's almost always better to try and settle a case than to go to court, because the cost of going to court is just so expensive. So I liked, the ethos of Rothley Law, and like you, I was intrigued by the fact that they specialize in this area. And as far as I'm aware, they are virtually unique in that there are very few firms in the country which specialize in contentious probate, court of protection, and probate. So, I think it's a really unique mix, and so far, I absolutely love it.
It's great, and I think we've spoken on a number of occasions,
Yeah.
and actually, so it is so refreshing to just
Mm,
actually, when you realise that these three strands just interlink so much, and
exactly.
it's grief and money one way or another,
Yeah. Yeah.
preventing it or
Yeah.
resolving it,
Yeah.
and I think that is very much what we're about, isn't
Yeah.
it? So, I mean, contentious probate, contentious trusts,
Yes.
they're quite, that's broad, isn't it? So
Yeah.
what are
Very
the sort of
broad.
main
Yeah.
areas would you say are
Yeah.
the people that you see?
So one big area is sort of contesting the validity of a will. And I mean, you can do that for a number of reasons, and probably one of the biggest reasons is things like mental capacity, but you also get undue influence. And if the will hasn't actually been done correctly, a lot of that took place over COVID, with people not able to meet. So the formal rules were relaxed, so you have electronic copies and so on. But that led to a lot of potential disputes with people not actually signing wills correctly. But there's also professional negligence cases against solicitors who have done wills incorrectly. I mean, it's quite common to do a will for, £150, which um, from our point of view is very cheap, because you can basically pay more than that for an hour of advice from a solicitor. And it doesn't mean it's done badly, but it does mean that inevitably it's very sort of pro forma, and a bit like a factory. And if you have a testator who is infirm or illiterate or has some other problem, then if that isn't picked up, then it's another reason that the will can be disputed, um, and potentially a claim brought against the solicitor who drafted the will. Um, so then there's financial abuse, which is moving more into your area, uh, sort of inter vivos claims, or claims when the person is still alive. And again, it's quite common that after somebody has died and people have fallen out over the will, that they also fall out over the period before they died. So if somebody was like the attorney for the deceased, then once they've fallen out with them, they accuse the attorney of stealing money from the deceased before they died. So there's that as well. But by far the largest area is what we call Inheritance Act claims, or Inheritance Act 1975 claims. And that probably is about, I don't know, 70 to 80% of the claims that we deal with. Yeah.
That's quite a lot.
Yeah.
So, tell me more. Tell me more about Inheritance Act claims. Because I actually am quite surprised at the numbers there. So,
Yeah.
yeah.
Yeah. Well, Inheritance Act claims are based on this act, Inheritance Provision for Family Independence Act 1975. And that itself was based on an earlier act, which actually came into force in 1938. And there is a bit of a myth in this country that we had testamentary freedom. And we've never had complete testamentary freedom. There's always been checks and balances. Any rights you have are always subject to the rights of others. And if you're in a family, then there are rules about who you can give your money to. But over the years, they have changed, and certainly sort of 1900s, it was very, very free to pretty much do whatever you like. And the, the public morality changed, and the Parliament were basically forced to come up with some laws which gave a little bit more support to typically women who had been left out when their husbands took on a second wife. And then when the husband died, he would often give all his money and inheritance to the second wife and her children, and disinherit the first wife and her children. And in Victorian era times, that was a massive change in status. And inevitably, the first wife and children potentially also, ended up on the state with benefits and all the problems that that caused. So there was this push to sort of change the rules. And essentially, what you have is a court is able to decide whether the potential claimant beneficiary has what's called reasonable financial provision. That's a wonderfully vague phrase. And inevitably, it leads to lots of argument. But the sort of claimants are, like I've already said, the first wife, but also you can have cohabitees because people live together these days, and they don't get married. And if they haven't done a will, then following the intestacy rules, intestacy being when you don't have a will, the money all goes to the family. None of it goes to the cohabitee. And you could have lived with somebody for 20, 30 years. So again, under this act, reasonable financial provision, it gives the court a lot of discretion to basically try and be fair to potential claimants. I mean, people would argue it may have gone too far now, because you have what they call adult child claimants, which is again by far the biggest category. And these are children of the deceased who basically don't get what they were expecting under the will. And again, these days, they could be estranged, they could be not talking to the deceased, they could have fallen out with them many years ago. There's there's a massive range of scenarios, but generally speaking, if the adult child is not well off on state benefits, can't really it has health problems, can't work, that sort of thing, then again, there's a sort of assumption that the parent should have provided something for them. So it's all very vague, but obviously with case law, it becomes more defined. And, the statistics show that sort of 80-90% of these claims never get to court. So the solicitors hopefully get together and talk about the sort of claims that are being made and the sort of financial provision that would be considered reasonable, and facilitate some sort of settlement with the families. And certainly, my experience is that it often leads to good outcomes. People are often fighting with family members, and once you settle one of these cases, it can lead to a degree of sort of family reconciliation. It can also, lead to them never talking to each other ever again. But as solicitors, we can only get involved up to the point where you have a settlement, and then you're not going to court, and then the rest is up to them.
Yeah, gosh, I mean, there's a lot to unpack in there, isn't it? And I
Yeah.
think, I mean, I'm really intrigued about this. First of all, the sort of that sort of Victorian philanthropy
Mm,
almost
yeah.
point, which I hadn't really sort of contemplated.
Mm.
And it's almost happy 50th birthday to the Inheritance
Yes, that's
Act, isn't
true.
it? And
Yeah.
my goodness, what has changed in that 50 years?
Mm,
And something I wanted to pick
mm,
up on, and I think it's something you've touched on, the financial abuse
mm.
point, and also the adult provision,
Childs, yeah.
which I wonder if we're gonna see more of that with an aging population,
Yeah.
requirement to simply work longer to
Yeah.
get your state pension, sandwich generation, where you've got people struggling financially, looking after aging parents, looking after children, as you say, who are can't get on can't get on in
On
life,
property ladder.
on property
Yeah.
ladder, and this and people who've perhaps had to give up work for caring
Yes.
reasons or ill
Yes.
health, or and then that, and again, from the sort of talking about the
Mm.
financial abuse one, and this is something obviously is quite a bit of a hot topic at the moment, is what we're seeing is this sort of perceived entitlement that
Yes.
actually I'm doing a lot for this person,
Absolutely.
I should therefore be compensated. And
Yes.
I'm quite intrigued in that because I'm sitting there
Yes.
saying, just because you're looking after mum or dad doesn't
Yes.
mean you should get money for it.
Exactly.
But actually, flip side, as an Inheritance Act claim, would you say that there's merit in that?
Um, there's only merit in it in the sense that it's definitely relevant background information. So the Inheritance Act has what they call Section 3 factors, and that refers to the Act, Section 3. And there's a whole series of things that the court must take into account. And um, there have been cases which confirm that the court must take all these things into account. So, if the court misses one of them out, then they can get appealed. So all these factors have to be taken into account, and in the end, it basically is everything you can think of under the sun, because obviously there's always a last factor, which is anything else. Um, so, so, so now I often have clients who, as you say, are caring for their elderly relative who then dies, and they can think that they should be compensated for the fact that they have been caring for them, and that isn't what the Act says. So there is no provision in the Act that says you should be compensated for caring for your elderly relative, but it is definitely a factor that the courts will take into account when they're deciding whether the deceased has given reasonable financial provision for the person who was caring for them. So yeah, all these things are something that should be taken into account. And when people tell me about weird and wonderful things that have happened in their family, you often say that's not strictly relevant, but let's make a note of it because it could be something you use if the case went to court and you were doing a witness statement. You would include it in there because, if it shows that they're basically a pretty good person, and they did their best for their relative, etc., that is something the court could take into account.
Again, shifting demographics all the time, and I
Yes,
think that's
yes,
that's what we're up against, aren't we? And I think it's shifting demographics, shifting social mores and
yeah,
societal expectations, but actually underpinning this is the law, and that's
yeah,
our job. We sit there and go, I absolutely hear you and I appreciate what you're saying, but I have to apply not only the statute but the case law that
yeah.
goes with it, and that can often be quite a difficult tussle when
Absolutely. I mean, one of the things I often say to people is that, my job isn't to advise on morality. My job is to advise on the law. But inevitably, the law was originally written with some sort of moral idea in mind. So the morality isn't irrelevant. But if you end up in court, you're looking at the black letter law. You're not thinking, what's the moral situation here? But when you're not at court, which is obviously where 80-90% of these cases get settled, that morality element is definitely something you can use in your negotiations.
It's really, that is really fascinating, that shift between the two, that sort of
Mm.
pre-settlement point. Actually, what we do as solicitors and lawyers is actually navigate that
Yeah.
before it actually gets as far as as courts. And
Yeah.
I know people might want their day in court, but we all know that's not necessarily the right outcome.
No.
And I think that this neatly leads into sort of the last bit that I want to talk about,
Mm.
and is this access to justice point, isn't it?
Yes.
I want my day in court. I want to be heard, and fundamental legal principles.
Yes.
But dare I say it, people are a bit nervous of using solicitors because
Yes.
they worry about the cost.
Yes.
And so, how does that work? I mean,
Yeah.
nobody sits there and goes, oh, I've just got a bottom, it's got an open checkbook to want to
That's
just
it.
instruct Justin to go and
Yeah.
do this and have my day
Yes.
in court. So,
Yes.
tell me about, the weird and wonderful word of funding.
Well, it is very relevant actually, both to inheritance disputes and particularly Rothley Law, and again was one of the reasons why I chose to join Rothley Law. So there's a thing called conditional fee agreements, and these have been around for a while. They kind of became really big with personal injury, and they have gone through various sort of iterations because they were considered too aggressive at one stage. But essentially, they are no win, no fee agreements. Now, that is a massive generalization, and there's a lot more to it than that. But essentially, the idea is you bring a case, and if you don't win, then you don't have to pay your lawyer. Whereas if you win, then you do have to pay your lawyer, and you have to pay an extra bit called a success fee. But there are lots of different ways you can fund the case. Private paying is the standard, which basically means you pay as you go. But you could also agree a deferred payment or payment on conclusion. So you still pay, but you don't pay until later. And again, usually you end up having to pay slightly more because you are basically benefiting from not paying at the beginning. And some of these cases can go on for several years. So there are a variety of ways that you can fund cases when essentially you don't have any money. With Inheritance Act cases, it's particularly relevant because often the claimant who is trying to basically get some money has not got the money that he wanted to under the will. So he is, short of the money that he was expecting. And certainly for sort of adult child claims, you're basically looking to not have a lot of money, have health problems, which mean that you can't go to work, and then you've got a more likely chance of winning your claim. So again, those type of claimants don't have any money up front, and then the opponent is typically the executor of the estate, and the executor of the estate obviously has all the estate money, and they will be able to draw on that. If the matter went to court, then the court could make a decision and say that the executor has not acted appropriately, and actually say that the individual executor is responsible. But until that point, the executor essentially has access to the estate money. So there's this massive disparity in terms of finance between a typical claimant and a typical defendant. So there is it's an area that's crying out for funding. And Rothley Law, I think, again, uniquely really, has an arrangement with a finance company, so they can offer conditional fee agreements and payment on conclusion agreements, which basically means that people who don't have any money could potentially employ a solicitor, Rothley Law, if Rothley Law decide that the case is worth it. And that is massive because there are so many people out there who have perfectly good cases but can't bring a claim because they don't have any money. And so they go to see a solicitor, they tell them their problem, and the solicitor says, "Yep, I think you got a good claim. It's going to cost you this much." And they say, "Oh, well, I can't pay." And then the solicitor says, "Well, I'm sorry, that's the end of it." Whereas at Rothley Law, we can offer them conditional fee agreements, payment on conclusion agreements. And again, I think, at least 50% of the cases we bring are on that basis. So it's something they are really good at. And as I say, I think that is pretty unique in Inheritance Act disputes at the moment.
It's fantastic, isn't it? I mean,
Mm.
as I say, to be able to even offer that,
Yes.
and that does take the, as you say, the expertise to understand whether somebody's got a good
Yeah.
case or not. But I think it's a really important point that as people who are perhaps vulnerable or
Mm.
have been disinherited
Yeah.
unjustly or unfairly can access justice, which is something I think we're all very passionate about as lawyers,
Yeah.
ultimately, one way or another, aren't we?
Absolutely. Yeah. Yeah. And I mean,
Fantastic.
for me, that makes it all the more interesting because obviously, you get these sort of weird and wonderful cases that really wouldn't go very far if you couldn't finance them to begin with. And given that 80-90% of these cases settle, um, I think it does give justice because you're not going to court, you're not having that huge expense, and one person wins, one person loses, and the winner has or the loser has to pay the winner's costs, which is almost always going to be unfair. Whereas when they settle, I think you get to what I would say is a sort of approximation of justice.
I think that's absolutely right, isn't it? I think that it does seem more balanced
Yeah.
in that rather than that unfairness of paying
Yeah.
the other side's cost. So, it's a fantastic thing that we're able to offer to people in these circumstances.
Yeah.
Justin, thank you so much. It's been absolutely brilliant talking to you about this, and going to really watch with interest what we have coming across and around, and certainly the things I know we get reported both in the paper and in court.
Yes.
But I have one very important question for you. What biscuit do you like with your coffee?
Okay. I have to admit I don't regularly eat biscuits with coffee, but if I did, I think I'd probably go to something like oat and raisin cookie.
Strong choice.
Yeah.
Strong choice. So, Justin, thank you so much,
Thank
and
you.
really appreciate you coming on.
No, thank you.